Welcome to everyone who came, and thank you. We're glad you're here. As promised in the presentation slide you see on the screen, we'll be following the course of a trial. First, I'll start with introductions of everyone and tell you a little bit about how this all came about, and then I will turn it over to Brian Nolan. This started with my relationship with Takanori Abe. He and I were in the trenches in 2007 in the Northern District of California on a design patent case. And it was really intense. There were a lot of parties involved. There was a lot at stake. And so many different things happened. I often say every trial something happens that never happened before. And many things in that trial happened that hadn't happened. And then I continued to stay connected to Takanori as he developed and circulated his analysis of Japanese trials with United States trials and other venues as well. That led me to understand that connections are important. And after we've been through the trenches, I do stay in touch with people. And everyone else you see on the screen are attorneys who had very different work, but they seemed to care about the same things we cared about, and we stayed in touch. So let me start with Brian. He and I worked on a trial last year because a colleague of mine, a longtime colleague of mine in the industry, was conflicted from working with him. So she trusted me. Her name was Lillian Romano. She trusted me to work with Brian, and we came about a lot of preparation and got to know one another intimately in the trenches. But don't take my word for it. His colleague, Rich McCormick, says, Brian and I met as junior associates almost 25 years ago, pulling all-nighters together in a trial war room in Delaware in one of the earliest biotech patent litigations. I know from this experience and the decades since that he's the James Brown of patent law, one of the hardest working attorneys in the business. There's no technology he can't master, no legal problem he can't wrestle to the ground, no big picture strategizing outside his reach, and no client who doesn't respect what he brings to each and every case that he works on. And I saw that firsthand. Following Brian, Larry Schatzer will elaborate on fact and expert witness preparation and many of the nuances that make or break an examination during trial. He and I began working together while he chaired the IP litigation department at Foley and Lardner years ago. We continued to work together most recently while at Strain PLLC. Larry specializes in patent litigation and has held numerous first chair jury and non-jury trial roles in cases in federal district courts and before the U.S. International Trade Commission. He surrounds himself with knowledgeable and talented attorneys who are drawn to teaching and who bring out the best in each other on behalf of their clients. He knows how to get into the nitty-gritty to get the most from everyone on the team, including his clients. I was in touch with his colleague, Stephen Nagy, who said the following. It is obvious, based on his experience and results obtained for his clients, that Larry is an incredibly skilled and thoughtful litigator. But as accolades sometimes do, these overlook the personal integrity, understanding, and open-mindedness that also make Larry a true counselor, both for his clients and his colleagues. It's always a pleasure working with Larry, and I count myself lucky to have him as a mentor. In the spirit of connectedness, I had also worked with Larry's client, Mayor Blonder, who said the following. In any case, Larry is my go-to IP litigator. He's a smart, strategic, very efficient with his time and with managing his team. He hones in on what needs to get done as opposed to throwing everything on the wall to see what sticks. Larry's also a great sounding board for ideas and is very receptive to an open discussion with competing thoughts. Next up, Michael Cryon will dive into opening and closings as they are improved with visual communication considerations. He and I were in the trenches together as well, most recently on a high-stakes trademark dispute with his partner, Michael Groh. Mr. Groh had this to say of his colleague. Michael is one of the most competent and highly respected litigators at Arent Fox Schiff. He's been the lead attorney in many lawsuits throughout the United States. He's worked with the firm's New York, California, and Boston offices. He is well known among his colleagues and opposing counsel for his integrity and hard work as a zealous advocate and defender of his clients' interests. And then rounding us out, as I started, Takanori Abe of Abe and Partners in Osaka, Japan, will bring comparative analysis as he explores U.S. IP litigation and shares his observations of foreign venues, including Japan. Again, I want to say the whole idea of connectedness is important to me, and every single person here speaking has had very different but significant pieces of litigation that we have worked together on. For the purposes of this webinar, we would like some interaction. I see people have arrived, and if there's any questions at any point, please click along the top of your screen and raise your hand, and we'll do our best. So with that, I'd like to turn it over to Brian to get us started.
Well, thank you for that introduction, Suann, and thank you for taking the time to put this all together. If we could just go to slide 4, please. So I'm going to be talking about opening and I'm going to be talking about the pre-case work that we deal with, where you're trying to get the judge on your side from the beginning, and I will focus on technology tutorials that often come up in patent cases, and as well as Markman hearings. Please turn to slide 5 now. Now, many of you in this presentation may understand this, but considering that we're doing it as a comparative view on United States and Japan and other things, just a few background issues that we have. First thing, when we're in federal court on a patent litigation, we are often in front of the same judge from the very beginning through the trial. He or she will have their initial scheduling conference with you if they don't give it to the magistrate, and they will be dealing with all of the issues from the very beginning all the way up to the JMOL motions that you might file after a trial. And so it's very important to use those opportunities before your district court judge at the outset to tell your story, to start presenting the facts in a way that your client is going to use them throughout the litigation. And there are very many instances where by telling the court your story and your client's story from the beginning, you will have opportunities where you could streamline the case or set the case up in a way that you will end up resolving in a favorable manner for your clients. In patent cases, oftentimes a claim construction decision, which will come from the court, the judge, could be determinative. It could get you out on non-infringement, or it may mean that you are going to infringe and you have to recalculate and refocus on invalidity arguments. By the same token, it may be able to set up some of your invalidity arguments where you thought you had a weaker aspect, but maybe you were able to broaden out the claim term to pull in more prior art or narrow it to exclude art. Following claim construction, oftentimes summary judgment is a way that we could narrow the issues, where the court will take issues away from the jury. And by educating the court from the outset as to what your arguments are and why they all make sense from the technology perspective, you may be able to streamline difficult issues and tell the case in the way that you want to tell it. And
Brian, I want to say here, you've been very good at understanding the attention that needs to be paid in order to make all that happen to the visuals. The visuals even at that stage are incredibly important.
Absolutely. And one thing that I would say is it's incredibly important to break this down and to use these demonstrative exhibits from the outset to assist you in breaking down the technology, weaving in the specific facts of your case into that technology, and then also weaving in the law. And that's where someone like where Suann, you and your colleagues understand this so well for us that we're down in the weeds with this. We know the technology, we know the legal issues, and we can come to someone like Suann and she could really break it down for us and saying, I'm getting lost here or I'm getting lost there. And it's vital that we use that skill set to really teach our clients or teach the court about where we want to go. If we could go to slide 6 now. So a little more background about the United States system and particularly how we deal with patent cases. So, as I mentioned, the case is randomly assigned to a judge. In certain districts, you may have a little more control on which judges that you get, but generally speaking, you're randomly assigned to a judge. There's no requirement that that judge has any technical background or any involvement in patent cases. Depending on the jurisdiction he or she sits in, they may have more involvement in patent cases. And so, if they're not technically educated on the subject and haven't dealt with patent issues that often, technology tutorials are a good way to start introducing concepts to the court. Now, several courts, Northern District of California, Eastern District of Texas, Western District of Texas, allow you to do these tutorials because they're pretty patent-heavy dockets. But if you're not allowed to do them, you can ask the judge, or you maybe work with the other side to put it in. And tutorials can range from all sides. They can be professionally animated tutorials with voiceovers that look like movies. They could be PowerPoints with animations in them, or they could be just textual. And again, this is where you would work with somebody like Suann to help you what you need to do, or what is most helpful to do to get the point across, understanding the economic factors that are involved in your litigation, the amount that it's worth, the client's needs, the client's positions. But this is where working with experts really helps you to decide what is appropriate. If we can go to slide 7 now. So in order to give you an idea of how this can be useful, I'm going to take you through some technology tutorial slides and markman slides that we used in a district court case to really tell the story. And just to give you a little background, so just to give you context, we were dealing with an antibody that bound to an antigen called CD20, and thus people would describe it as an anti-CD20 antigen antibody. The patent in issue here actually was a method of treating cancer by administering an antibody that bound the CD20. And the term specifically in the claim, as I said, was an anti-CD20 antibody. So now we had to start laying the groundwork in our tutorial for how a person of skill in the art, when the patent was filed, would understand anti-CD20 antibody different than it would nowadays. And because of that distinction and the other evidence and arguments, why the court should conclude that our client's antibody didn't meet the claim as described. So if we can go to slide 8, please. So the first thing that we did when we were trying to come up with a way to deal with this is we wanted to set the case for the judge and set the judge in the timeline to understand it. So timelines to me are very powerful tools. They're easy for us to understand. And so we laid it out. We identified the first time somebody had identified an antibody that bound to this particular antigen. And then we walked it through all the way to, and you see back in 1988, somebody finally had an understanding of maybe what this antigen looked like, because this antigen is on your cancer cells and you have to try to bind it. And then we put a flag in the sand for when the patent was filed. And so if we can maybe go to slide 9, please, to get you a better idea. So what we showed the court is, look at this protein that's on the cancer cells. This is what people thought it looked like. It was inside the cell, it was inside the cell membrane, and there was a little portion that was outside the cell membrane. That is what people thought this protein looked like on the cancer cells. And we were setting this up for the judge because we're saying when the patent was filed, if you ask somebody what an anti-CD20 antibody would look like, they said it would be something, or how it would interact with this antigen, it would be something that would bind to that area because that's the only area that was exposed. That's the only part where the antibodies could bind. So here we're not talking about the patents. We're not talking about the legal arguments. This is the technology tutorial. We're just setting this up so the judge starts to think about the facts and the technology in the way that we want them to think about it. Now,
Brian,
yes.
when you presented that, was it adversarial? Did the other side do anything else?
Well, interestingly, oftentimes the technology tutorial you present on a CD or you upload it as a file. So you may not even, there may not be a hearing where you're doing this. So this is just something that you send to the judge. So the judge and the clerks can look at it, and they look at it usually before any key hearings, and it kind of gives them the foundation. So oftentimes there's not objections here. You don't want to be overly argumentative in it, but you basically can say and set the stage for how you want to set it, so you'll align with your following arguments. So if we could go to slide 11. So the next thing that we did is we kept in the time frame, we continued the timeline, and we kept in that November 1998 date, which talked about when the patent was filed. But then we started explaining that our client's antibody was different than antibodies that existed before. Antibodies that existed before were made up of mouse and human DNA, but our antibody was made up of only human DNA. And that's how the antibody was made. And because of that, it was thought that made the antibody bind differently. And it made everyone think about this CD20 antigen differently. Because if you look now here, the structure that's shown here is a tad bit different. There's a part that thought was buried in the membrane, was now realized because of the work that our client had done, was exposed. And once it was exposed, that meant antibodies could bind to it. But this was not known until our client had done the hard work to identify it. So again, we're not making arguments here. We're just explaining to the judge, this is how the technology was understood and how the technology developed. If we can go to slide 13. And then with that, again, not from an argumentative perspective, but we looked and said, so judge, you see on the right, that's how the antibodies before, at the time of the patent, were understood to bind, and that's the area of the protein that they bound on. But look at ours is quite different. Ours binds over here. So although these are binding to CD20, they are a little different, and you should consider them differently. And so that was the setup that we gave from a technology perspective. And so now we wanted to use that from a legal perspective and take it on. How can we use that to further our arguments? We've given the judge the timeline. We've given them how to understand the technology. And so then we moved into our Markman arguments that followed on a few months later. And with that, if you can go to slide 15, I could give you a little background on that. So if you see on the right, the patent owner basically said anything that binds to CD20 is an anti-CD20 antibody. And that would be a general understanding. But we said, because how the technology was developed and other arguments we were able to make, that we think it should be limited to antibodies that bound in the same manner and at the same location that the antibody in the patent had shown. So that's why we talk about binding to the same epitope. And epitope just means the area on the protein that the antibody is binding to. And so when you want the judge to narrow this, you have to give him some reasons. And again, working with Suann and people like herself and experts, you can start walking through the evidence, the factual evidence specific to your case, coupled with the legal support for it. And so that's what we did. If we go to slide 18 now.
Before we do that, Will
Sure.
Truba has a question, Brian.
Sure.
Did the other side object to that presentation? Was the building of the binding to the small loop already evidence in the case, or alleged?
Well, at the tutorial, there's a little more flexibility, because since it's only going to the judge, we don't have to worry about the evidentiary issues as much. But there was no dispute that that is the way that ofatumumab had bound. So our expert would have come up and explained that, and our expert in our claim construction, we would have had an expert declaration associated with that. There would have been about background technology. In that background technology section of the declaration, the expert would explain all the facts and evidence that supported that with exhibits. So you don't need it for tutorial, but you're right, Will, you do need to put it in once you're trying to use it to support your case going forward.
Thanks, Brian.
And so if we can go to slide 18. So in slide 18, the first thing we start off is now we need to give factual evidence to the judge, and facts specific to here. So the first thing we wanted to do is, if you click through all of these, you'll see we took what the examiner had said. The examiner, when looking at this, said, we think that this is overbroad because you don't have sufficient support for any type of anti-CD20 antibody. And so they say the examiner thought to get all the anti-CD20 antibodies, you would have had to do too much work, and it's only the antibodies that are in the patent that are really supported. So when the plaintiff had gotten that rejection during the patent prosecution, they had to respond. And again, we wanted to, and it's better to show the judge the actual words, not summarize it. So here, this is what the examiner said on the right and highlighted. And if we go to slide 19, we were able to give them what was said in response. And what they said in response was that a person of skill in the art would know how to identify antibodies that bound to CD20 with the similar affinity and specificity as rituximab. And so we use this language to say, look, they're directing you to a specific type of binding, a specific type of area. And that was our linchpin to say, maybe this is narrow, maybe the general application or general definition shouldn't apply here. And so again, so much better when you use these demonstratives, when you make them visual, when you're working with Suann and her colleagues, and they'll say, let's animate this, let's bring it out, let's highlight it, and then you give them the actual evidence. This is not what you're saying. This is very easy for the judge and his or her clerks to see what was made. And so the next step, now we've given them the technology background, we've given them factual evidence in our case, now we have to lead them to the law. Now we have to show them how this all works. And if you could go now to slide 22. So so slide 22 here again is just bringing home for the court. They said it has to bind like rituximab did. And here in slide 22, you see we're showing exactly how the antibodies in the patent bound. And you can see in no way do they bind in a way that's close to the areas that our antibody had caused to be understood. And then with that background, again, then we move to legal arguments and the case law for it. Now, I will just give you one example of a legal argument. We have several others in this, and this is only parts of the tutorial in the claim construction hearing. So if we go to slide 24, but again, making it easier for the judge, working with experts that know how to present this. And if we could just click all the way through, we've now given them the precise cases to say the term, you have to use how it was understood. You can't enlarge it to embrace after file technology. And these are just examples, but what's most important I find about these technology tutorials and these Markman presentations is the judge takes them back and it gives them a roadmap, particularly the Markman presentation. It gives them a roadmap. It gives their clerk a roadmap to the background technology they want to cite, to the specific factual evidence that they want to cite in their opinions, and to the legal support that they want to cite. So this is just a snippet, but this is much more detailed when we present it. And what is useful here is once you tell that story, then as Larry will explain when he's dealing with fact witnesses and expert witnesses, and Michael will explain in opening and closing, you can just crib off that. You can pull from that. You can see what the judge liked or what maybe didn't resonate with the judge. And then they'll take you through how you can use this very skillfully in the other aspects of a case to get your point across. And then Takanori can tell us give us kind of a distinction how we do things a little bit differently here in the United States, and sometimes maybe people would scratch their head at it, but that's kind of why it's so important. And I think, Suann, how you always help us to be able to break these difficult concepts down, because they are difficult concepts for the judge to understand and the difficult concepts for the jury to understand, but it's imperative that's how use skill set like Suann you have to be able to say, that's going to work, that's not going to work. And we really just want to use it to kind of get an unfair advantage to go into the difficult parts of the trial that Michael and Larry will talk to you about now.
Thank you, Brian. Larry? I don't see any questions. Okay.
Larry. I'm going to talk a little bit about fact and expert witnesses. And, fact witnesses sometimes are not the first thought that comes to mind when we think about using demonstratives in a patent trial. But I think there are some ways that we can very effectively use demonstratives with fact witnesses. And if we could go to slide 30, please. As the patent owner, you have an invention story, and some invention stories can be very compelling. And most trials, even patent trials, are morality plays. They're competing stories. And when you have a powerful story about how your invention came about, how it makes things better for the members on the jury, they can connect with your case and with you and with your client in a way that's important to show that this was an aha moment. It was a real innovation, and it was an innovation that made things better for everyone. If you're the accused infringer, you often use your fact witnesses to talk about the difference between your product and the claims in the patent. And sometimes using your own witnesses can be more compelling, or at least add to what your expert's going to say. Often there's prior art that's out there that your expert's going to talk about, but maybe it's prior art that's not a patent. It's one of what we call 102G prior art, or it's prior art that arises from a prior invention where the evidence for it is not patent documents, but it's papers or technical journals or other information where a fact witness can add to that. And I think we need to think about instances where we can present that fact evidence while still using an expert demonstratives, not just confine our thinking to demonstratives are for opening and closing. They're for experts, and they're not for fact witnesses. And I wanted to use an example from a recent case we worked on with Suann to sort of illustrate that. We had a client who manufactured ground fault circuit interrupters, or GFCIs, and everyone knows what these are, whether you know it or not. They're in your house and in your business. They're the plugs that you see in your kitchen and your bathroom that have the two buttons on them, the test button and the reset button. And the purpose of those outlets are if you put something electrical into water while plugged into that outlet, the outlet will shut itself off and save you from being electrocuted. Knock a radio into the bathtub, or knock your toaster into your sink full of water. The GFCI was invented in the early 1970s by a professor named Dao Zhao at Stanford University. And very, very quickly, they became ubiquitous in houses, and building codes required them. The National Electric Code started to require them because they saved lots of people's lives. The problem with GFCIs, though, they came to find out as they began to become widespread in use, was that a lot of them were being installed by people who were not following the instructions, or they were homeowners retrofitting their house or whatever. And if you put a GFCI in and you don't connect it properly, in other words, if you connect the power coming in, what we call the line, and the power going out to the next outlet, the load, if you do what we call reverse wiring, if you wire them incorrectly, the older versions of GFCI wouldn't protect you. You'd still get power from the outlet, but if you dropped your hairdryer in your sink, you're still going to get electrocuted. And these problems were very common because the wires were often the same color. People didn't read the instructions. They thought you just stick it in there and screw the wires on and you're good to go. And it worked. And they thought everything was fine until something terrible happened. So our client challenged their engineers to try to find a solution to this problem, so that if you put it in incorrectly, if you reverse wired it, you wouldn't get electrocuted. And our inventors came up with a solution to this problem. It involved disconnecting certain connections within the GFCI and a few other things. And they solved this very big problem. They saved a lot of people's lives. And we wanted to be able to explain that and show the jury the value of that invention. So we created a demonstrative to do that, working with Suann. And I'm going to show you two versions of it, because as we created the demonstrative, we also learned a lesson about how you go about creating these to not create some problems for yourself. So here's the first version. We started by showing a regular electrical outlet. Person's drying their hair, and let's go to the next slide. And they drop their hair dryer into the water. What happens? We go to the next slide. They reach in to pull it out, and they're electrocuted. All right. Moving on to the next slide. This is a GFCI receptacle. If it's properly wired, you drop it in to the sink, you reach in, and you're not electrocuted because the GFCI worked properly. It cut off the electricity because it sensed that ground fault, and it cut off the power and saved this person's life. The problem was that if you reverse wired your GFCI, you were going to get the electrocution problem, even though you thought you were being safe. Let's go to the next one. Okay, so let's go back. Let's stop there. So we made this first set of slides with the hair dryer. We sent it to our client and we said, here, and the inventors, and said, here's the slides we want to use for your testimony. And our client came back to us and said, well, that's nice, but you know that hair dryers have their own GFCIs in them, a version of a GFCI, a fail-safe, so that even if you have reverse wired your GFCI or you have it plugged into a regular outlet, it'll still protect you, because people dropping these hair dryers into a sink full of water is very common. And so there's this fail-safe backup method of protecting people. And we thought about that and we thought, well, if we use this with the client, the other side's going to get up on cross-examination. They're going to ask a few questions about that, and it's going to diminish the value of our demonstrative. Not that our demonstrative was inaccurate, but we've sort of created a credibility issue for ourselves. We've created an issue where our demonstrative can be used against us. It can be used to show we're only telling half the story maybe, or in some way diminish the story we're trying to tell. So we went back to the drawing board and we created another demonstrative, but this time we used another common example, which is a toaster. And you have a toaster, you have a bagel, and your bagel gets stuck in the toaster. You stick your fork in there, your metal fork in there to try to get your bagel out, and you're electrocuted because your GFCI is not properly wired. It was reverse wired. With our client's invention, even if you installed it incorrectly, you would be protected and you would not be electrocuted. So, and we can show that here. So, two lessons from this. One is, if you've got an invention story to tell or a fact story to tell in your trial, think about whether you can illustrate it or make it more powerful and more persuasive by using a demonstrative exhibit like this one. And secondly, you got to road test your demonstratives. You got to put them in front of your witnesses and your expert and other people who may not be involved in your case and say, pick this apart for me, play devil's advocate, be the other side. How would you cross-examine this to make sure you don't have any holes or issues? And we worked a lot. We spent a lot of time on this demonstrative with Suann, and I know Suann has some thoughts as well about how this whole process worked in our case.
It was our pleasure, Larry, but it was very funny when the first meeting the attorneys said, and we want the person to die. And so we did the best we could not to get gory. So that's why we decided that maybe the red hair thing would kind of alleviate the whole, dying in a bathtub scenario. But the back and forth is something that I've been doing this for a very long time, and I constantly have to teach attorneys that it's fairly iterative for lots of reasons. And you just touched on most of them. Your client has to have input, your expert has to have input, and you, by trying what we tried with the first set, that seemed like it made sense, and we had to kick the tires and test it out. And so the only problem for us was I had to pick different artists to do different scenarios. They create the environment with the toaster, and one of our team members said the toaster makes more sense anyway because people really do stick their fork in to get bagels, especially. And so that was fun to be able to go back and forth, but it is one challenge that we're constantly teaching, that the back and forth is how you get to the solution you need.
Exactly. And so we ended up with what I think was a way to demonstrate to the jury and make them feel empathetic to our client, because we took a real life situation they could find themselves in and explained how our inventors were able to create a situation where they or their family members would not be electrocuted, even if they thought they were safe because they had a GFCI installed. So it was very helpful. So now I want to turn to talk about experts, and that's where we always think about using demonstratives in patent cases, right? Our experts are trying to take very often complex technology, and they're trying to explain it to a lay jury and to a judge, and they're trying to explain the basics of the technology. Some of these cases, like the one Brian talked about before, we don't talk about or think about antigens and antibodies very often in our day-to-day life, but we do spend a lot of time thinking about cancer. We don't often think about the outlets that we've got in our walls, right? And whether they're GFCI or not. So we have to lay that groundwork for the jury. Then we have to explain the patent to them and, what patents are and what a claim is and how all that works. And then we have to compare the claims to the accused product. We have to talk about other patents and prior art and compare that to the claims. We have to illustrate, if we have it in our case, secondary considerations evidence, which I'm going to talk about in a moment. And then we need to summarize evidence that often are found in multiple documents, and that's always a challenge, and that's what I'm going to talk about here in a moment too. And I'm going to use an example from the same case I was talking about, which is that, as I mentioned, when the GFCI was invented, it was a great invention, but as it began to roll out, people realized there was this reverse wiring problem, and people tried to solve it in a lot of different ways. They changed the instructions. They put labels on the outlets and the where you attach it to the wiring. They put alarm bells on it or whistles or various things to try to get people to stop installing them correctly. And none of those things worked. And what our client realized is the way to solve the problem is to make the device so that it can't work that way, rather than try to change people's behavior. And our expert needed to illustrate this. And in our case, we were fighting against allegations that our claims were obvious. And one of the pieces of evidence that we had was secondary considerations evidence. There's evidence about whether a patent claim is obvious that asks the question, was there a long felt but unresolved need to solve this problem? And closely related to that, was there failure to solve the problem over a long period of time? So what happened is we had these various examples, and what we needed to do was show the jury that there's lots of them, and they happened over a long period of time. Now, the problem is if you just put these things in front of your expert and you show it to him and say, well, what's the date of this? And he tells you, and then he explains what it is and why it didn't solve the problem. And you go to the next one and you do that over and over and over again. Makes for a nice record if you're in front of the Court of Appeals or if you're arguing post-trial motions, but the jury's going to fall asleep and really not get the point, because the point for the jury is just lots of things over a long period of time. So how do you illustrate that? So as Brian said earlier, timelines can be very helpful. And that's what we did working with Suann in this case. If we can go to the next slide with the timeline. So we created a timeline, and let's go to the next slide. And we populated it with our first event, which in our case was September of 1978. So we put that date on there. We hand the expert this particular piece of prior art, and we put the key quote up there saying what the problem is, what the issue is. And so the jury isn't just listening to the expert or maybe seeing the exhibit up on the screen. They're actually seeing this timeline, and they're seeing the first point. Let's go to the next slide. Then we have another data point. So we put that one up. We put the information up there once again as the expert talks. The other thing this does is for your expert, as you know, any of you have put an expert on, you can prepare and prepare, but the expert has a lot to talk about. There's a lot of documents, a lot of things to keep straight. What I try to do with these timelines is I use them as a memory device for the expert to keep the expert on track. So often I will ask the person in the hot seat to go ahead and put these points up, maybe even before I've gotten very far with the expert about this particular document, to remind the expert of what we're talking about next. Now, you have to be careful because technically that might be objectionable because you haven't really laid the foundation yet for that evidence before you're putting it up in front of the jury. But
we have, Larry, remember we were talking about that. We have had instances where the hot seat person did get ahead and the other side objected, and there was a moment of levity where the judge said, "Are you objecting to leading by graphics?" And in fact, they were. So that,
Exactly. And technically, it's objectionable, but frankly, I don't want to make that objection if I'm sitting on the other side, because the jury doesn't like it when the lawyers are jumping up and down objecting because you look obstructionist. And the judge just wants to get through all of this. So most judges, I'm not going to say that there aren't some who might sustain that objection or at least admonish you a little bit, but most of the time you're going to be able to do this. And so in addition to creating this device to allow the jury to see this rather than just hear it, you're creating something that helps your expert smoothly go through the evidence, not have to try to memorize everything or remember, makes your expert a lot more comfortable. So let's quickly go on through the rest of these, and you can see how we populated this whole thing. And this is important because here we get to the aha moment, because here's when we filed our patent application. So here's what we've done now. We've put this in front of the jury and said, these are all the failures. And now here's our invention. Look, here's our 2 points. Look, there are lots of dots on here. And look, it's all the way from 1978 to 1999. That's a long time. That's what we want the jury to know. Lots of incidences of failure over a long period of time. At the same time, we've gone through each of these documents, put them into evidence, created our record for post-trial motions or appeal or whatever, but we've created this visual for the jury to get the key point. And then this, I don't want to get into Michael's part too much here, but this is something then that you can put up on closing and remind the jury. And when they see this, they'll remember that and remember what you talked about and remember what the expert testified about. So you've taken this large body of knowledge and information and evidence, and you've distilled it down into something that makes your point and that you can use again. And so, I think that is valuable and effective. And I can think of lots of different instances where you can use something similar to this to make the same point, because very often in these patent cases, there are lots of instances where we're accumulating information or documents or evidence and then getting to a point. And anytime that happens, whether it's over a period of time or just merely accumulating it, illustrating that graphically can be very effective.
seeing no questions, I will turn it over to Michael Cryon in 1 second. The idea of a timeline that many, many cases require, all different kinds of litigation, almost always somebody says, "We need a timeline." This one, Larry, I thought was different looking. I remember when we were developing the idea that the months were down the vertical and the years were across, because we wanted to spread out. We wanted those dots to really be spread out. And that was one of the ways we did it, rather than what people often do with timelines is the stems and the flags. This actually, I thought, met your need a little bit better.
I agree. I thought it was really helpful, and it varies depending on what point you want to make with your timeline. And I think that's one of the things you have to ask yourself, because I think so often we get so caught up in the nitty-gritty of these cases, we don't put ourselves in the shoes of people on the jury. But our point here was so very, very simple. It was just lots of things over a long period of time. I mean, just to distill it down to its most basic element, and you have to start from there, and then work out the details.
Yeah. And I've also been involved with cases where, just like this, it didn't require necessarily a high quality graphic. We just did little sketches on an easel pad and said to the expert, "Go ahead and draw it yourself. We'll give you a little guides, but draw it yourself, because that's the point." And they if they have the wherewithal and the presence of mind to say, in May '84 and in February '93, that can be effective too. I don't want this to feel like it has to be computer generated graphics. It's just about the visual and the interaction with the visual. Michael Cryon.
Well, Suann, thank you. And thank you to Brian and Larry. It's been fascinating so far. And I think for this module, let's kind of talk about both opening statements and closing statements. We'll kind of compare and contrast them a little bit, just to give you a flavor of how we approach it in intellectual property cases. Openings, in an opening statement, generally word slides and exhibits, you can go to the next slide, are generally permissible. Here we have some examples, and you can go in and use, next slide, please, documents that both sides already know are going to come into evidence. We can use word slides, such as we use in the next slide at slide 72. And importantly, exhibits that both sides know are going to come into evidence. You can use in the next slide, we talk about enlargements, call outs from exhibits, and even using rhetorical questions uh, without making too much of a closing argument. But we are generally allowed to take an exhibit that both sides know will come into evidence and use that exhibit, but call out relevant parts of it and bring the jury's attention, kind of setting the stage for what will be shown at trial. Another thing that we do allow in opening statements, and we frequently use at slide 73, and um, in addition to enlargements, call outs, and rhetorical questions, and now so we go to 76, we do have this comment box that you might have seen. One thing that can't really get away with, we don't do in opening statements, argumentative statements. Those are generally seen as inappropriate. And Brian mentioned earlier, or actually a question came up earlier when Brian was talking about whether the other side objected. Both sides do see the slides, generally speaking, ahead of time and can make objections either beforehand or right at the time. Argumentative statements are generally not going to be allowed in opening statements, but certainly something like the next slide, 77. Um, photographic evidence that's going to come into evidence to show the differences between products and to defeat a claim of confusion among those products can certainly be something that we do. Contrast that when you're proceeding to make your summation, when you're doing closing argument. Let's go to slide 78. At that point, argumentative statements are permissible. Now, certainly, and it says here, if statements are so manipulative that they're unduly prejudicial somehow or present a significant danger of confusing the jury, yes, those would be deemed inappropriate. But if you look at slide 80, which came from a recent case we won, a jury trial in a trademark infringement trial in which the jury held that no confusion was proven. You can use evidence and marshal it in front of the jury on summation to kind of show the jury that their conclusion that there's no confusion between the two products is supported by the evidence, all the evidence that they saw at trial. And this all came about, Suann talked about connectedness and trusting the people that you work with. Uh, and Suann and I and Suann's whole team worked very closely on that trial. Fortunately, it had a very positive result. But I agree with Suann. It's important to rely on your colleagues who know and understand these issues, know when to emphasize the different points that you have to make. And taking a step back at all of the discussions we've been having, to us, lawyers in the US, these are all very important stages of the litigation. Certainly the pretrial issues like the Markman hearing Brian was talking about, summary judgment Brian also mentioned, and of course Larry covered those all important witnesses. Opening statements and summation to the jury, those to us are all signal events during a trial, during a litigation. And I know we're going to hear from Takanori and some nuances and differences in the different systems, but certainly we have covered a lot of those very important stages of litigation here today already.
Michael, before we go to Takanori, we have another question. Was there survey evidence in the example from the trade dress case? I believe there was.
Yes. It was fascinating. Both sides had survey evidence. So there was dueling survey evidence put before the jury. There were many experts, but both sides did have surveys. Their survey did purport to show consumer confusion, but we were able to attack that survey and support our view with our own survey as well, Suann. But that's a very good question.
Excellent. Fantastic. Takanori?
Suann, one thing before we jump to that from a housekeeping perspective, if you
Yes.
could just go to slide 68, there's something that we have to tell our participants. So for participating in this program, we did seek CLE credits. In order to get the CLE credits, I believe Suann may have shared with you a form, an evaluation form. In order to receive the CLE credit, you must record this CLE code patents 29 on the form, and you must return it within 10 days of today to cle-events@mayabrown.com. And those instructions are on the form that Suann provided. But if you want CLE, please follow those steps. Thank you, Suann.
Thank you, Brian. And I'll show it again at the end. And with that, let me introduce Takanori Abe, the gentleman on this call I think I've known the longest.
Thank you. I would like to talk about the comparison. Next slide, please. I have already published the article on this topic, published on the Managing Intellectual Property magazine. So if you are interested in, please visit the website of the Managing Intellectual Property magazine or our website, and you can download them. Next slide, please. These are the topics I'm going to cover today. Next, please. I would like to introduce the comparison of the Japan and US and Germany. As a Japanese lawyer, I have litigated in the District Court, IP High Court, and the Supreme Court in Japan, of course. But besides that, I have many experiences of the US litigation. I have 2 jury trials experience in the US District Court and experience in the Federal Circuit and the Supreme Court as well. And also, I have litigated in the Düsseldorf District Court and Appeal Court in Germany, and also the Federal Court of Justice in Karlsruhe. So I would like to introduce the comparison based on my own experience. Next slide, please. First, let me introduce about the United States. Next slide, please. My first trial experience was with Suann, and I was very much amazed by how the PowerPoint slides were made for the jury trial. Suann was a team member even before day one and sat in the war room next to the lead counsel every day. And the lead counsel gave the idea to Suann, and they discussed, and then Suann made it into the PowerPoint slides. I was astonished how the lead counsel's idea was materialized in the figure in the PowerPoint slides made by Suann, and it was a very big fun. I look forward every day how the jury will react to the PowerPoint slides made by Suann and explained by the lead counsel. So that was my big pleasure every day during the trial. And then, so what I learned from this experience is that to win the US litigation, it is very important to retain the competent trial lawyer and the jury consultant, but it is indispensable to retain the excellent, competent graphic experts like Suann. Next slide, please. Japan. Next slide, please. This is our courtroom. There are judges in front, but we don't have jury, unlike in the United States. And the judicial research officials are the JPO examiner, Japan Patent Office examiners, who assist the judges because they have a technical background. And the technical advisors are the scientists, professors, who understand the latest technology, so educate the judges about the latest technology. And attorneys for the plaintiff sit on this side, and attorneys for the defendant sit on the other side. Next slide, please. And the attorneys for the plaintiff explain the technology, explain to the technology to the judges using the PowerPoint slides. And next slide, please. And the attorneys for the defendant do the same. And next slide, please. And I heard from the former chief judge of the IP High Court, or that he said it is much easier for him to read the 50 pages PowerPoint slides than reading the 50 pages brief because the figure will ease his understanding. And judges are very good at reading the briefs in a very quick way, and they can understand it well. But even for those judges who have such a skill, to understand the complicated, difficult technology, the PowerPoint slides is useful in Japan. And as this photo shows, we use the PowerPoint slides in the courtroom, but and it is improving, but it is not yet the level of the US litigation because we don't have Suann in Japan. Next slide, please. Germany. German are very different. Next slide, please. As I explained, I have litigated in these courts. And next slide, please. In Germany, in the brief, they don't use figures, photos, tables, just the character. And I and the client were very astonished when we observed that the German IP judges understood the super complicated technology. We thought that the German IP judges who doesn't have technical background will not understand correctly, but they almost correctly understood such a very difficult technology and asked the question in the beginning of the hearing.
Takanori, we
yeah.
have one question on your last slide. Was the judicial research official from the Japanese Patent Office in your slide where you showed?
Yes, exactly. Yes.
It was, okay.
Because most of the IP judges in Japan do not have technical background, and then of course we attorneys educate the judges and let them understand the technology well. But inside the court, there is a judicial research official working every day with the judge, and they explain the technology to the judges so that judges can understand the technology from their side, not from the attorneys. And going back to Germany, so what we have observed is that the German system is completely different from the US system or Japanese system. They don't rely on the figures, they don't rely on the photos, tables, but still they understand the technology, complicated technology in a correct way. So we observed a very high ability of the German IP judges. Next slide, please. So United States again. Next slide, please. I understand the PowerPoint slide is used so that the lay jury can understand the difficult technology in the patent case. But well, it may not be only for the layperson, but also for the specialist, because I heard that the physicist in Soviet Union, when he moved to the United States, he was told that, okay, from today you are in the United States. When you publish the article, you have to write the physics article in an interesting way. Otherwise, your article will go to the trash box. So he should write the physics article in an interesting way. And the readers are, of course, professional specialists, not the lay juries. But still, American culture is to let the writer write in an interesting way, catchy way, so that the readers will be attracted. Next slide, please. And US and Europe are very different. Next slide, please. The Hollywood movie, the beginning, already very exciting, like the speed. I'm a big fan of the speed, but the European movies are different. They start very slowly, and I will fall asleep. And this difference are the same in the way of writing the draft and the brief. My experience is that our US lawyer opened the brief with a sentence which says God is in the detail. Then he attract the reader judge and let the reader judge read the lengthy 100 pages brief. Next slide, please. The American and German are very different. Next slide, please. when I asked our own German lawyer, please include the figures, tables, photos in the brief. Please have some catchy sentence in the brief. Please have some impression in the brief. All are rejected. They said that's an American way. That's not the German way. So the Germans emphasize the doctrine well, and they completely think in a deductive way. Next slide, please. And the Americans and the British are different as well. Next slide, please. Although they are Anglo-Saxon. I heard from the UK lawyer that their American client asked them, please write in our way. But the UK lawyer refused, saying that that American way will not be accepted by the UK court. I enjoyed watching the Phantom Opera in Broadway and West End in London, although the same musical, but slightly different. So I think this difference exists in the way of writing the brief as well. Next slide, please. Zelensky. Next slide, please. Zelensky gave speeches to help to seek the help from many countries. He emphasized September 11 in the United States, the Prime Minister Churchill in UK, and the war in Germany, and tsunami in Japan. He used the direct expression in the United States, UK, and Germany, but he used the indirect expression in Japan, understanding the Japanese character. So he didn't mention about the Fukushima plant, but instead he only mentioned about Chernobyl. So I understand, I believe that what Zelensky depicted as a Japanese character is correct. Next slide, please. However, in the courtroom, next slide, please, because the litigation is to persuade the judges, the attorney's attitude may be different from the normal Japanese. Attorneys maybe in Japan are more direct. So in the patent case, as I explained, we attorneys use a PowerPoint slides like the Americans, although the standard is not the same. And there is a famous criminal lawyer who opened the brief saying that this case is exactly the same as the Akutagawa's famous novel or the spider's thread. And then he let the judge read the lengthy 100 pages brief, which is exactly the same as the American lawyer. So I think the Japanese attitude is beginning to be similar to the US one. Next slide, please. So thank you very much.
At this point, we'll open it up to questions. If anyone has anything that these presentations have sparked, we're open for any questions you might have. Coming up. Of all I think we did a nice array. We created a nice array of differences in the way we approached cases. One thing I learned probably halfway through to now, maybe 10 or 15 years ago, I learned that of all the things you saw, something equally as effective could have worked as well. That you probably learned this in law school, but there's more than one successful way to solve problems. And the same thing applies for trying to visualize, and as you're visualizing, learning your case and learning the material, it's really complicated to make something simple. And as Brian said, it's really important to make something simple at all different stages of the trial process. And so I think that's something that may help you understand before you embark on, oh, we just need some pictures. We just need to illustrate this or that. I think that's something that usually surprises people.
Yeah, I think, Suann, one thing that I think is kind of interesting, Takanori did a great job discussing the differences, how he approached things in Japan and the United Kingdom and Germany and the United States. But when Michael and Larry or myself are dealing with stuff, we also have to think about it almost jurisdictionally. What type of demonstratives or arguments we may make in Delaware may be very different than we may make if we're in Colorado or in Iowa, and just what is going to resonate. And so it's really difficult to just have a one size fits all way of doing it. There just may be what's more familiar to the likely jury pool and that judge So again, to your point, there's not just one way of doing this. And to Larry's points, there's so many of these demonstratives that end up on the floor throughout the course of a development of a litigation. It's much nicer now that they're all electronic and they're no longer the big boards that we used to have to make.
Although they have a place, they do have a place. Those boards still have a place.
They do have a place. It's much easier to carry a computer than carrying 25 of those boards into a courtroom on a rainy day. But yes, but yeah, I think it's important to think about not only the technology, but understanding your audience is going to differ, your jury pool is going to differ, your judge is going to differ from experience, and you really should try to gear it in a way that breaks it down, that's going to be easiest for that audience.
Right. And the way you would determine that is through pretrial research and listening to the people in the venue. There was a case early on, I would say 1999, 2000, where we were going into a rural county in Mississippi and no one wanted to bring trial technology, which was at its beginning of its explosion, where everybody was going to start to use it. So we had to come up with a couple of different things like the boards, Brian, like make sure we have boards ready to bring in. We don't want to look too fancy with this electronic stuff. And anything that went up on the screens, the jurors were captivated by. And so it was exactly opposite of what we thought, because we thought we were in this rural area that maybe they'd be turned off by it, but they were captivated by it. So it had the opposite effect, but we listened and acted accordingly. Those assumptions, I think, are really important when you're trying to decide what you show and how you show it.
Suann, I agree. Do you see Lisa's asking a question about UK lawyers and whether they are allowed to prepare
Yeah,
witnesses and experts for an upcoming trial?
curious for perspectives on demonstratives and jury consulting in general in the UK. One of our jury consultant colleagues said that she moved there for family reasons, and when she moved there, she thought she would explore it. And I remember her saying, "The English hate us, but the Italians love us." Uh, Anybody have any other insights into that question?
I would say this. I went over and observed an English patent trial because I was going to try the same case on the U.S. equivalent of that patent later that year. And the thing that struck me wasn't so much about witness preparation as the distance between the solicitors and the barristers. And whereas we all get in the same room during trial and strategize and plot, the barristers and solicitors, they don't quite talk as much. And as far as preparing the experts, I wasn't involved in that case, and I don't know how much that differs from the U.S. But I do know that dual system in the UK creates sort of a situation where the advocacy is a little more, I want to say neutral, because certainly you're advocating for your client, but it's not quite as in depth, and there is sort of this difference. And my sense is that the solicitors prepare the witnesses, and the barristers sort of come in and later on and sort of take over the reins, and that's a dynamic that I'm not used to, and I'm hesitant to comment on it, other than I noticed that quite a bit when I was over.
Okay, we have another question from Will Truba. In all of your experiences, did you use your expert in the case to assist with tutorials or use a different person for the tutorial?
Well, I often at least have the expert that I want involved in the tutorial. Sometimes we do have multiple experts. We'll have a testifying expert, and we'll have a non-testifying expert, particularly if you want to run some tests and make sure that the results are what we think they should be. But irrespective of whether you're really relying on the testifying expert to do the tutorial, they need to be involved in some format, because you don't want to lay out the technology in a way to the court and get the court and the clerk and the judges thinking in a specific way, and then your testifying expert comes in and presents it differently. And so you need consistency. So getting your technical experts involved early and identifying them early, there's a tremendous amount of benefit from that. If you're plaintiff, oftentimes you may lock up experts beforehand simply because you want to limit the experts that would be available to your opposing counsel or the defendant. But even if you're not doing it for those, strategic reasons, I think it's vital to be comfortable with your experts early on and to use them in everything that you're doing and the arguments that you're making, and run the legal arguments by them and how you're going to use it. Because at the end of the day, they're going to be the ones that have to present those facts and those opinions. And those facts and those opinions are only going to be as good as they present them in a believable way. And if you force an expert into a position that they're slightly uncomfortable with, it always comes out. And so having them involved early on at the tutorial stage, I think is vital, because like I said, it's consistency is key, and you don't want them to slip up when they're in their deposition or on their stand. And so if they've given you this insight from the beginning, it's very unlikely that they'll back away from it in the end.
Yeah.
Let me add to that I agree 100% with Brian. I always make sure that all of my technical experts sign off on the tutorial. And as far as them testifying, it really varies. Some judges like to hear from the experts, or they leave it up to the lawyers. And if I have a choice, I always put one of my experts up there. Sometimes they want it on paper. Sometimes they want the lawyers to do it. So you don't always have an opportunity to put your expert up there. But it leads me to think of something else, which is that in my experience, you always want to try to posture yourself where, not just in the tutorial, but we're also giving a tutorial in trial to the jury, because the jury doesn't see that tutorial we prepare for the judge, at least not in that form. And my experience is whoever makes the technology understandable to the jury, the ones that allow them to grasp why they're there and what's going on, they have a distinct advantage in winning that case, even if their arguments ultimately are weaker, because the jury is empathetic to them, because these are the guys that help me understand why I'm here. So a lot of what Brian talked about as far as what you use with the judge in a tutorial, you want your expert to present that to the jury, even if you're going second and the other side's already done that, because you've got a different take on it, a different spin on it, or you want to emphasize something that's different, or maybe you just do it better. I've seen some experts who've gotten up first and either jumped right into the technology or explained it badly. And I can't emphasize enough that, from interviewing jurors afterwards and other things, that if you're the side that allows the jury to grasp why they're there or gives them that aha moment, you're halfway home at that point. So there's a bleed over between that tutorial you prepared for the judge and what you ultimately put in front of the jury.
And on the expert note, I want to say as technology has increased, I got into this industry in the mid 90s, and we all are PowerPoint experts now. I mean, third graders are learning to do really fancy things in PowerPoint, but experts come with often their own graphics. They say, "Oh, graphics are in the report," and they're good for the report. There are other reasons and other things we can do to improve them for trial. And I don't mean branding. I don't mean, making it pretty. It's really more about how is their testimony going to interact with that visual. Now, some experts have said we don't want anyone to touch what we've put in our report. We're going to just show the graphs from the report. And there are some moments where that makes total sense. Just let them do their own thing, even if the jury can't see it or can't understand it. It's complicated, but there are plenty of reasons why at least it should be considered. That question should be considered. Should that be shown? Should the report exhibit be shown? Or should we do something different to accent and help the testimony?
Well, Suann, in the case we were just talking about, we had multiple experts from many different disciplines. We talked about survey experts, and we had one, but we also had an industry expert, bottle production expert, and Suann, they all ended up providing helpful information on how to persuasively present their information. And all of their information has to work together and come together at trial.
Right. That's right. And that again, that actually helps with the evolution of the whole idea of how you make something visual. Is you have to be able to react more and more quickly these days, and nothing is ever finished. I mean, I started with creating file names, and it's so funny. I get even notes as recently as this morning that said this is final, and then we got final. This is the final. So we just use numbers. But yeah, this whole idea of the graphics technology is it's important. There in the chat right now is the CLE accreditation form. We do have about 10 minutes left, but I just want you to know it's there, and you can also email us at Debbie@Suann Ingle, and we'll send it to you. But we did put is there a link? Debbie, please send me. Oh, just send the email to her. We did send it out to everyone who had registered by yesterday, but we do see some more people today. One of the other things I thought might be helpful to mention is in elaborating on the iterative process of visuals, there are all kinds of reasons why you can be deliberate about your design. There are things about courtroom visuals, I think, that benefit from no design, but no design is a design. So it's a difficult process when someone thinks this really looks good and yet it can't be read, or they have no sense of typography and they just think that underlining and making something bold is better. But studies after study shows that bold doesn't always make something more visible, and underlining does the opposite. Underlining something makes it actually a little bit harder to read. So there are plenty of those little nuances that I think make for opportunities. They create opportunities for you to improve upon what you have. And I now have gotten more and more PowerPoints that are done in-house at law firms that are fine as is. That's how I like to start. You could do just fine with this, but with a couple of ideas, maybe this would improve it. So I have noticed that happening, and I thought that would be something to mention here. This is not it really isn't a sales thing for graphics. It's the way you approach graphics. Everyone sort of agrees graphics are vital. It's just the way you approach them gives you opportunity to look really good.
Let me add one more thing, and that is I always, in every case that I'm in that I think is going to really go somewhere and likely go to trial, I try to put my team together as quickly as possible. And that means I try to hire my experts early, the staff, the lawyers that I want working with me on it early, everything like that. One of the things I do early is I call Suann and I tell Suann, I've got this case. I'm probably going to need her help. Here's what it's about generally. Keep her in the loop. Tell her what the schedule is going to be. And, sometimes you get pushback from your clients. Well, we're not going to need graphics for, till trial or, for a long time. And that may or may not be, but I have found, and I know Suann appreciates knowing what's going on because she's got other clients and other things to do. And you're going to need to be able to have her time when you need it. So that there's a logistics part of it, but also I spend an hour or two telling her about the case. I send her the patents. I let her know what's going on so she can start thinking about it. And she's not charging me a lot of money to do that. And I imagine she thinks about it, not charging me anything because I've told her about it. And I get a lot of value out of that. And so you might get pushback from your clients, but I view my graphics person as vital as my document production people and the people who give me, who maintain the database of my, discovery production and my experts and all of that. They're part of the team. They need to be in early. They need to be kept in the loop. And you get a lot more value out of that, and you can develop a relationship, and you end up saving your client money because Suann knows what I need often before I need it, and so I don't have to spend a lot of time talking to her or explaining it to her. There's value there, and I know not everybody sees graphics experts the same way. Some people just view them as vendors. Personally, I think that's a mistake.
Well, and I love to say we don't charge anything for the graphics. We only charge for revisions. That's what it's turned into. Everything is a revision, which usually helps. Thank you, Larry. That's very nice of you to say. Anybody else have questions or additional thoughts on what we've covered? A lot. Takanori, do you see any more visuals being created in any of your hearings that you didn't see before? Are things being used that that where nothing was used before?
Yes, in Japan, we are using more PowerPoint slides, and in important, complicated cases, we even use videos and spend lots of money. But we don't have graphic experts. We don't have a specialist for the litigation or patent litigation, so the quality is still not comparable.
We got to thank you. Excellent presentation, Will Truba says. Thank you for all your insights. I do want to say one other thing that's fun is I find myself in the war room very often with very highly educated attorneys who can't believe it comes down to PowerPoint. At some point, it comes down to PowerPoint and that's because PowerPoint itself has evolved. I mean, when I first got into this, PowerPoint was just a pipe dream. But we can do so much now with this software. In fact, Microsoft, we're always complaining, why doesn't Microsoft highlight better and things like that? But it is hilarious at that moment, almost every trial where someone says, God, I didn't cover this in law school. Anyone else have we have a couple of minutes left. Any thoughts that came to you while we were talking?
I thought this was great, Suann. Thank you for being really the impetus to put this together and allow us to give some insight on this topic.
I was pleasantly surprised that all four of you just jumped at the idea and thought, let's do it. We didn't even know what it looked like 6 months ago, but we thought, well, we've got enough to say. We'll figure it out. And I do think this will help people who watch. Thank you again for coming. And I'll close us out with that.
Thank you.
Thank you.